The penalties under the new EU AI Act can reach 35 million euros, or 7% of a company's global revenue. That's the top of the scale, reserved for the most serious breaches. And it shows how seriously Europe is taking this. If your AI applications touch the European market, this law applies to you, whether you're in Berlin, Boston, or Bangalore. The deadline is already this August, and it affects almost anyone using a chatbot or generating content with AI. The good news is that EU AI Act compliance is very manageable once you understand it. So let's take the legal complexity and make it simple. We've read and analyzed the documents, and we'll walk you through what actually changed, what you're responsible for, and present a clear roadmap to get ready. Quick context. The AI Act is Regulation 2024/1689. It was signed in June 2024 and entered into force on the 1st of August that year. It's the world's first comprehensive law governing artificial intelligence. If your AI systems are placed on the EU market or used within the EU, this act affects your business. Basically, if you are covered by GDPR, this act applies too. The core idea of the regulation is stated as such.
To promote the uptake of human-centric and trustworthy artificial intelligence while ensuring a high level of protection of health, safety, fundamental rights.
The higher the potential for harm, the stricter the obligations.
The AI Act follows a risk-based approach, classifying AI systems into 4 different risk categories.
That framework is the key to everything else. Every AI system you use gets sorted into one of the 4 tiers, and that classification determines exactly what the law requires of you. And here's the part that surprises people. Classifying your systems is your company's responsibility, not the commission's. There's no approval step where a regulator signs off on your tier. You make the call, you document your reasoning, and a national authority can review or challenge it after the fact. We'll dig into exactly how to make that call in the sections ahead. But this is a big law. 13 chapters, 113 articles, and not all of them take effect at once. Some parts are already being enforced. Others don't apply until 2027, and a few not until 2028. So before we go further, let's get the timeline straight, so you know where we stand right now, and which parts actually apply to you, and which parts of the law you might want to read more closely. Chapters 1 and 2 apply from February 2nd, 2025. That's important because Chapter 2 is the list of banned practices, and Chapter 1 includes the AI literacy duty. So the prohibitions and the training obligation have been live since early 2025. The rules for general-purpose AI models switched on from August 2nd, 2025, then the big one for ordinary businesses. The regulation's general application date, including the transparency duties in Article 50, is August 2nd, 2026. That's this summer, and it's when the AI Office's enforcement structure comes into effect. The May 2026 Digital Omnibus pushed the high-risk deadlines back further to give companies and standards bodies time to build the necessary infrastructure. Under that amendment, standalone high-risk systems move to December 2027, and high-risk AI and regulated products moves to August 2028. Digital Omnibus is the first major package of amendments to the AI Act, designed to simplify compliance and streamline the rules. Negotiators reached a provisional political agreement in May 2026, and by July the package had been approved. It was needed to adjust the expectations set back in 2024, when neither the market nor the legislators themselves could ensure proper compliance under the existing infrastructure. These amendments show that EU regulators are willing to adjust to what companies can realistically deliver, so expect the rules to keep evolving as implementation matures. 4 things changed with Digital Omnibus. 1. The timeline. High-risk deadlines got extended. 2. A new ban. AI systems that generate non-consensual explicit imagery, so-called nudification tools, are now prohibited outright. 3. Relief for smaller companies. Simplified paperwork and easier access to regulatory testing environments for SMEs and startups. And 4. Less overlap, where an industry already has its own AI-specific rules, and the Commission can now trim the AI Act scope so you're not complying twice for the same thing. Let's go tier by tier and start at the top of the pyramid. Tier 1, unacceptable risk. Article 5 lists the practices that are prohibited outright, no compliance path that makes them okay. These have been illegal since February 2025. Social scoring. AI that manipulates people by exploiting their vulnerabilities, scraping facial images off the internet in bulk. Emotion recognition in workplaces and schools. Predictive policing, based purely on profiling. And, as of December 2026, nudification tools. Most everyday business AI doesn't land here. But if you're building employee monitoring, HR scoring, or customer profiling, it's worth reading Article 5 closely, because this is the tier with the highest penalty, up to 35 million euros, or 7% of worldwide turnover. High risk. This is where the serious compliance work is at. If a system meaningfully influences a decision about someone's health, their livelihood, or their access to services, it's probably high risk. There are actually two sub-tiers here: safety-regulated products governed by Annex 1 and standalone systems in sensitive domains governed by Annex 3. Group 1 is for when your AI is a safety component of, or is itself, a product already covered by EU safety law and requiring a third-party conformity check. This is about medical devices, machinery, and smart vehicles. Group 2, described in Annex 3, covers biometrics, critical infrastructure like water, gas, and electricity, education, including systems that score exams or decide admissions, recruitment, filtering CVs, promotion and termination decisions, access to essential services, and this explicitly includes credit scoring and pricing for life and health insurance, law enforcement, migration and border control, and the administration of justice. Penalties here reach 15 million euros or 3% of global turnover. However, the system is not automatically high risk if it only performs a narrow procedural task, or improves the result of completed human work, or doesn't materially influence the decision. But if the system profiles individuals at any point, it's always high risk. And if you determine a system isn't high risk, you must document that assessment before deployment. What are the compliance requirements for this tier? The first layer is what the system itself has to have. That's Articles 9 through 15, a risk management system that runs across the whole life cycle. Data governance, your training, validation, and test data has to be relevant, representative, and as error-free as possible. Technical documentation, drawn up before the system goes to market and kept current. Automatic record keeping, so events are traceable. Transparency to the people deploying it with clear instructions for use. Human oversight built in, so a person can actually understand, intervene, and if needed, stop the system. Accuracy, robustness, and cybersecurity appropriate to the risk. The second layer is what you as the provider have to do around the system. Put a quality management system in place, run the system through a formal conformity assessment, draw up an EU declaration of conformity, affix the CE marking, and register the system in the EU database. In other words, high-risk AI gets treated much like a regulated physical product. The third layer lands on the deployer, the organization using the system, under Article 26. Use it according to the provider's instructions, assign human oversight to people with the competence and authority to do it, monitor how it performs in the real world, and report serious incidents to the provider and the Market Surveillance Authority. Keep the logs for at least 6 months. And if you're deploying it on your workforce, Article 26 says you have to inform the affected workers and their representatives first. For some high-risk uses, Article 27 adds a fundamental rights impact assessment before you go live. Tier 3. Limited risk. This is where most businesses using generative AI will find themselves. Chatbots, virtual assistants, tools that generate text or images, and deepfake generators. There are just 4 transparency duties. Tell people when they're talking to an AI, mark AI-generated content in machine-readable format, notify people when emotion recognition or biometric categorization is being used on them, and label deepfakes and certain AI-generated text. Tier 4. Minimal risk. This is spam filters, recommendation engines, AI scheduling, and most productivity plugins. The regulation places no new obligations here at all. It's still good practice to record that you classified them this way. The one thing the Act does invite is voluntary codes of conduct. You can choose to apply some of the high-risk safeguards to lower-risk systems, but it's opt-in, not required. There's another cross-cutting category worth naming: general-purpose AI models. If you don't build foundation models yourself, this is not about you. Article 53 sets 4 baseline duties on every provider. Keep up-to-date technical documentation of the model, including how it was trained and tested. Hand downstream developers enough information to meet their own obligations when they build on your model. Put a copyright policy in place, including respecting the opt-outs creators can set on their work, and publish a summary of the content used to train the model, following an AI Office template. Open source models get a partial break from the documentation duties, but not from the copyright policy or the training summary. And Article 51 defines a higher tier: systemic risk. Models trained using more than 10 to the power of 25 floating point operations of compute. Over that line, you take on 4 more obligations: state-of-the-art model evaluation with documented adversarial testing, assessing and mitigating systemic risks at EU level, reporting serious incidents to the AI Office without undue delay, and adequate cybersecurity for both the model and its infrastructure. Let's zoom in on that August 2026 deadline. What takes effect now is Article 50, the transparency duties. Breaching these duties carries the same penalty as high-risk violations, up to 15 million euros or 3% of turnover. 1. If someone's interacting with your AI, like a chatbot, you have to tell them. There's a sensible exception. You don't need a disclaimer where it's already obvious to a reasonably observant person. So, an obvious novelty chatbot may be fine. A bot designed to feel human is not. AI-generated or AI-edited content needs machine-readable labeling. The law asks that these solutions be effective, interoperable, and robust, as far as is technically feasible. There's an exception where the AI only performs standard editing and doesn't substantially alter the content. If you're using emotion recognition or biometric categorization on people, they need to know. And don't forget about GDPR as well here. Deepfakes and AI-generated text on matters of public interest, like art, politics, journalism, have to be labeled. But that the law is actually lighter than it sounds. If the human held the final editorial authority over the content, it's not considered AI generated by the EU AI Act. Like this video, we use AI so we don't pull experts out of their work for something like voicing the script, but the content is produced by humans using AI as an assistant, not the author. This rule is more relevant to agentic systems producing tons of AI-generated content with little to no supervision. Okay, where do you actually start? We prepared an 8-step roadmap to structure the steps your business has to take to meet these regulations without panic. You don't have to do it all at once. Start with what's already required and build from there. First, build AI literacy. This one's live right now. Article 4 requires that the people working with your AI actually understand it at a level that fits their role. Second, put someone in charge. Without a clear owner, compliance often gets overlooked. Your data protection officer is the natural fit, given the GDPR overlap. Third, inventory every AI system you've got, vendor tools, SaaS subscriptions that offer AI tools, and the shadow AI your employees adopted on their own initiative. Ask your teams if they use LLMs to process reports or even use an Excel plugin. Once AI is used for work, your business becomes a deployer with obligations, even if, under common sense, it's a simple time-saving use case. For each one, what it does, who runs it, what data it touches. Fourth, classify each system through the 4 tiers we covered. And here's the part people skip. Write down your reasoning. Article 6.4 requires it for anything you decide isn't high risk, and it's the first thing a regulator will ask to see. Fifth, for anything high risk, run a gap analysis. Compare what you do today against those Article 9 to 15 requirements. That shows you where the engineering work is, and you've got until the 2027 and 2028 deadlines to close it. Sixth, even when AI comes from a vendor, you as the deployer stay responsible. So your contracts need to cover risk classification, documentation, and incident handling. Here's an easy checklist of what needs to be settled with your AI system provider. Seventh, set up continuous monitoring. Compliance doesn't stop once you're done with the first big push. Monitor performance, watch for anything that could bump a system into a higher tier, assign a named owner, and report incidents. And eighth, anchor it all to the trustworthy AI principles: oversight, robustness, privacy, transparency, fairness, accountability, and societal well-being. When your documentation reflects those, it becomes a lot easier to explain what you've done to your customers, your partners, and your regulators. And a note for smaller companies: your penalties are capped at the lower of the fixed amount or the turnover percentage, and your paperwork is lighter. But you still have to classify, disclose, and govern. No exemptions there. Here's the reframe we'll leave you with. Yes, this is a compliance obligation, but it's also a trust signal. Your customers and partners increasingly want proof that your AI is governed responsibly. Clear documentation and transparent AI features are quietly becoming a competitive edge. The deadlines are pressing, but the roadmap is manageable when you start early and work through it step by step.
Do you need help navigating EU AI Act compliance? NAX brings together engineering proficiency and regulatory knowledge. Every system we classify, document, and govern is assessed against real production conditions, so the risks we surface and the controls we build reflect how your AI actually behaves and hold up when regulators examine them. Connect with our team to build your roadmap to compliance.